Hello, everyone, and welcome to another episode of Off the Record. Today, we are joined by partner Cameron Wilson.
Hello.
His expertise involves unfair dismissals, unfair labor practice disputes, and length and breadth of immigration law, which is what he's going to be taking us through today. And in addition, Cameron is quite an avid gym attendee or gym athlete. I'm not quite sure what to say. But yeah, thank you so much for joining us today, Cameron.
I'm happy to be here.
Thank you. So today we're going to be covering the labor of immigration law. And as we all know, this topic is quite politicized at the moment. This podcast is not going to be delving into the politics of it, but we are going to be focusing on the employment law considerations of the topic. So before we get into the nitty-gritty, Cameron, I think if you could just give us an intro as to how immigration plays a part in employment law in a workplace. Why would someone care about immigration law?
Well, I think to answer that, though, and again, trying to stay away from the politics, but this has come sort of to my attention through dealing with these matters, dealing with the police, dealing with the Department of Immigration and Home Affairs, speaking to the workers on the ground and the unions. And it ultimately comes back to the unemployment rate that we have right now. And as it seemingly keeps rising, and I think the youth are being more and more represented there, there's an understandable concern that we would need to regulate the hiring of foreigners. Ideally, and from my experience, it should be on a shorter term to sort of fill a gap, because we want to be uplifting, local communities and having, I suppose as well, you want where you're working to be represented by people who live in that area as well. So there's a need for it. The need is understandable, to ensure that we don't go and focus on hiring foreigners, to the detriment of the local population. And also in doing so, circumvent, the labor law legislation, which, again, what's come to my attention through practical matters is a lot of employers think they can do this.
Okay. So in terms of looking at the legislation that you're referring to, what act are we looking at?
So we're looking at the Immigration Act.
Okay.
And for anyone listening, if you're an employer, I would suggest that you read it. Very easy to read, simple, plain language, not confusing. What the Immigration Act does, it sets out essentially obligations on employers. And again, I'm focusing on the employer here. And what it says is that the employer cannot hire anyone who's not permitted to work in South Africa.
Okay.
And it then goes a little bit further, and it places people call it the obligation of good faith, but it places a duty on an employer to ensure that they are aware of the employment status of their foreign employees.
Okay.
Again, in my experience, some employers are very good at that, and some employers are not good at that. And I always say to my clients as well, 9 out of 10 times, if you haven't done enough. There's a question over the validity of the documents. There may be no documents. The document may be promised to be brought next week. It never comes, but you've employed them and you keep them employed. So if and when there's a raid or someone comes knocking to have a look, then there's big panic as well.
Okay.
And I don't believe, and we'll get into it, is that I don't think employers, and this is what has come out in these practical matters that I've been doing, employers aren't aware of the consequences of their failing to
follow the Immigration Act.
People, generally, employers believe that, okay, well, unfortunately, the foreign employees in my employ will be arrested and be deported. I'll just have to find new employees. It's not that simple. The Immigration Act makes it a criminal offense to knowingly employ illegal, undocumented foreigners. So there's liability on the employer as well.
And not just on the employee.
And the reason I chose to speak about this as well, the reason this law hasn't changed, it's been around here forever. But in recent times, again, maybe it's because of a political push, but there's now real enforcement of this. And clients who didn't believe that they were going to be detained and kept in a cell for 2 nights are now being kept in a cell for 2 nights. And it's been quite a wake-up call.
So how does this play out in real life? So I know you emphasize the aspect of an employer not knowingly employing someone who is not permitted to work in the country. So let's say I am a foreign national. At the time that I applied for a job, I was permitted to work in the Republic.
Yes.
My documents have since expired. And because of the administrative issues at Home Affairs, I am in the process, but I'm not successful. What does that employer do?
See, this is what's coming up with my clients, what makes it so difficult. So because the obligation on the employer, that duty of good faith, it requires a level of proactive behavior. I'm dealing with a matter right now, and obviously won't disclose the parties, but it is frustrating in that I have a client who was raided, had around 30 foreign employees and its employees, some inherited, all with documents. It turns out that these documents were forged. The employer had no way of knowing. The employer did take the reasonable steps, as you suggested, to get into the contact of the Department of Home Affairs to say, look, we've got these documents. Are they legitimate? They didn't say they were concerned because there's nothing to be concerned about, but they were doing their diligence as they should. Obviously, no response from the Department of Home Affairs. And when it came down to they were then inspected, the employees were found with these falsified documents. The foreign employees were arrested, and so was the general manager. And unfortunately, the way it's playing out now is that to prove exactly what you're saying, we need to do that through the criminal process. We've had to make representations to the state to say the charges should be withdrawn because there's no way we knowingly continue to hire undocumented foreigners. It clearly shows. And our intention of even emailing you the documents shows that we thought these were legitimate. But that's the predicament that the employers are finding themselves in.
Yeah.
And what I would say, again, and it's difficult, and I know my clients they give me a lot of pushback for this, is I suppose you've got to be a bit more proactive. Have your HR attend the Department of Home Affairs for the day, then take the documents with them, get into contact with someone, create a paper trail to show that until recently, in the year that you're being inspected, we have submitted
You've done all that you could.
Done everything we could. And I think what's come out to me as well, is that with other employment related matters, if you're not paying the right wage or if you're not applying the right leave tariff, the Department of Labor or whatever bargaining council will come and issue with a compliance order, and they'll give you 14 days to comply, and then you pay what you haven't been paying. That doesn't work like this with immigration. Immigration comes and you get charged in the criminal process. So you don't get 14 days to fix your documents, to figure out what you're going to do with your undocumented foreigners. You then are now liable for a criminal offense, and that process then runs. So it makes it a bit more difficult. You need to almost have your documents in order at the time in which you're being investigated.
So that would, I think, if I'm correct, work in a formal work environment that is easy to regulate. So when we turn to an irregular or casual work environment, so to speak, so, small scale construction workers who wouldn't ordinarily ask for any documents, even from a South African. So how would an employer, treat that situation in the event that they were to be raided at their site or casual workplace?
I would suggest that they take extra precaution.
Okay.
The reason I say that, and this is my opinion, when going through this legislation, obviously it's there to regulate skilled foreign workers and how long they can stay in the country, because obviously we want to upskill local employees or citizens and then have them take those positions. But the criminal liability aspect, in my opinion, I believe it's almost tailored towards that sort of employment, where I won't go as far as to say you're trying to circumvent labor legislation, but you're taking a risk. You're not checking the documents of anyone.
You're not as strict.
Yeah. You're not likely paying what you're required to pay. And another risk is, and this has also come up now, is that what employers don't realize, is, and once you get stuck with this, is the Constitution provides that every person within the Republic, is guaranteed the right to fair labor practices, not just citizens. So and we've seen the case law on this, if you employ a foreign employee and it turns out that his or her documents are not legit, you cannot simply terminate and say, sorry, you don't have legitimate documents, you need to leave my employ. You still have to follow a fair process and a fair procedure, which would then be the disciplinary process. And you may be taken to the CCMA.
Okay, let's backtrack a bit. So how would that play out in the event that as an employer, I'm trying to correct what I've done wrong? And at that time, I didn't know. It's come to my attention. I'm now dealing with a foreign national employee who doesn't have any documents. So how do I start quite an administrative heavy process of disciplining, and looking to terminate that employment relationship if this person isn't documented?
So what I've found with some of my clients, and I think this is a good idea, if you regularly hire foreigners, or if you may very well hire a skilled foreigner on a certain visa, to put into your employer, because they will be on a fixed term contract, to put into their contract that it's an obligation on them to ensure that their documents are up to date.
Okay.
HR would then do, I believe, regular checks every 6 months just to check that the documents are still fine. And should that not be the case, should your employee have misled you, effectively, you could discipline them for misrepresentation, dishonesty, breach of contract as well. And obviously it's not nice talking about the potential ways you can get an employee out, but this is just to protect the employer's business. And again, you get stuck in this with one of my clients. We're in this sort of catch-22 where we're saying, how do we remedy this? Exactly that. We can't, half our employees are still being detained. We can't dismiss them. How are we going to give them notice? How are we going to do all of this? Are we going to hope that they don't come back? Some may come back. You get stuck in this gray area as well. And it is difficult to navigate. And it is admin heavy. And it's difficult to have that criminal process run concurrently with your own internal processes.
Thank you so much, Cameron. That has been a lot of information for us to absorb in this episode. We are going to be back with another segment where we dig deeper into the practicalities of this issue and where Cameron explains exactly how he helps employers and employees as an attorney specializing in this field.